Now, typically as valuers, and I'll defer to you because you're the expert valuer here, and when we value assets or intangibles, such as the right to exploit a patent, it's generally quite clear what object is being valued. But privacy,
yeah.
I mean, it certainly doesn't meet the accounting definition of an asset. And while some jurisdictions around the globe might recognise the right to privacy, Australia does not. So even should a defendant be found guilty of breaching privacy, the key stumbling block to awarding damages is that the plaintiff has not actually suffered any financial loss. And in this regard, Australia is not unique. And that is exactly the question the UK Supreme Court is currently considering or determining in the case of Lloyd versus Google, which was a massive claim that was brought in 2019.
Yeah.
So for the moment, our discussion on valuing our personal information, our privacy in a litigation context remains largely conceptual. Although, when saying that, I mean, then there may be avenues where it is entirely relevant, such as, for example, the misleading, deceptive conduct that's currently being brought by ASIC against Google, and where the courts may need, I guess, some sort of context or reasonable basis for determining the fine for actually misusing the data. And, that's where we are now. But I think, given where we are moving with cybersecurity breaches, it may also become, this conceptual framework may also become useful should the courts be facing large class actions in cybersecurity breaches or in claims where there have been, for example, the improper uses of cookies. But if we're going to devalue privacy, we're going to need to have an overall approach to guidance, one that will get us around that stumbling block where the victim who suffered the data breach has not really suffered any financial loss. Now, I know my suggestion might be a little controversial because it doesn't actually sit well with legal principle. But given that we're talking conceptually, I think it's appropriate to maybe flip the perspective of loss from what the victim has lost to actually the enrichment obtained by the defendant company who has not been consistent or secure in the way it deals with and monetizes our personal information.